Court will call People versus Robert Geese, 26T884. If you'll come on up and have a seat at the table. And then I show we have Ms. Morissette and Ms. Shireman for the People. All right, so I show that we're set on for a motions hearing. I don't show that there were any motions. I believe the motions that were previously filed had to do with obtaining discovery. Is that correct, Mr. Geese?
Yes,
Okay. And how do I say your last name?
it is Geese.
Geese.
As
Okay.
in Canada, excuse me, Canada Geese.
Okay. All right. So I have not received any endorsement of witnesses or defenses for your case. So I take that to mean that you won't be calling any witnesses other than possibly testifying yourself. Is that correct?
Your Honor, thank you, first of all. Good afternoon. I filed the motion for discovery, and there are 6 points, actually 7, but 6 points within that motion that have not been answered. And I also filed an affidavit of truth, and that has not been answered. Therefore, I don't understand how the court can move forward. I do want to correct the record on a couple things, if I may. Do I have your permission to read this into the record?
So let's go back to the question that I asked first. Are you going to be calling any witnesses? Because you did not file any endorsement of witnesses.
I don't know how we can move forward calling any witnesses without answering the motion and affidavit that's before the court presently.
Okay, why don't we start then with your motion for discovery? What exactly is it that you're claiming with the motion for discovery?
Do I have standing to read this into the record, first of all?
You don't have to ask for standing, so.
Thank you. Respectfully, for and on the record, I am Robert Geese, a living man of the Union, a non-belligerent or enemy of the state, and I occupy the office of Executor and Co-Trustee for the Nole Me Concari Express Trust. I am here propria persona in that regard, not pro se, by special appearance only, not generally. Further, I'm of the age of majority
Let me
by both the age.
Can I stop you for just a second? I am not going to consider claims that you're saying that I can't proceed on the case because you are not a citizen or anything like that. We're not going to proceed that way, okay? So did you say that you had some actual discovery issues that you needed to address?
Your Honor, respectfully, am I being denied my due process rights of being able to read this into the record?
You can file whatever you'd like, but no, I'm not going to sit here and listen to you just read a document into the record, okay?
I object.
Okay, that's fine. So did you have any actual discovery issues for us to address?
The discovery I filed, it's in writing. I don't know that it's necessary to sit here and read everything into the record. You just said that you don't want me reading into it, and now you're contradicting that with something else.
Have any actual discovery issues? Is there some part of discovery that you believe that you have not received?
All of it. Nothing's been answered.
Okay, so this is not a situation where they have to answer questions, okay? This is not a civil case where you get to do depositions or ask interrogatories. As part of a criminal discovery, they're required to give you some documents through the case. Did you receive the discovery?
Did I receive what discovery?
Okay, have the people provided discovery to the defendant? I believe so.
Sorry, double checking through the workflow, Your Honor.
Before we jump into today's courtroom chaos, you're going to witness something that has become increasingly common in courtrooms across America. Defendants who believe they've discovered a legal loophole that somehow exempts them from the same laws everyone else has to follow. But, as you'll see, confidence and legal knowledge are not always the same thing. Our first case features a man who insists that unanswered affidavits, trust documents, and self-declared legal status somehow prevent the court from moving forward. The problem? Courts operate on actual law and procedure, not internet theories. Pay close attention to how the judge handles these arguments. Notice that she repeatedly tries to focus the discussion on relevant legal issues, while the defendant continually attempts to steer the conversation toward concepts that have no bearing on the criminal case before the court. It's a fascinating example of two people speaking almost entirely different legal languages. Then later in the video, things get even more interesting. We'll meet another familiar face who has managed to bring the same style of arguments into an entirely different state and courtroom. This second defendant spends much of the hearing asking questions about bonding requirements, jurisdiction, and legal procedure while simultaneously revealing just how little preparation has gone into his own defense. As always, watch closely and ask yourself, if you were facing criminal charges, would you trust internet legal theories over established courtroom procedure? By the end of this video, you'll see exactly why judges often spend more time explaining basic legal concepts than actually discussing the charge aspects.
Can you let me know what discovery you provided?
So that would be all the evidence from the case. So that would be reports, just like criminal history. Looks like there is body-worn camera available. Basically, anything in our case file that's evidentiary would be provided to you. Typically, you have to go to the front desk of the DA's office and pick it up because there are large files, so they'll burn it on a CD for you. So if you haven't picked it up already, it's probably sitting behind our front desk ready for you.
Have you picked up that documentation yet?
I've never been given any notice of anything, and
So
the
we
question I have is this so from,
discussions about how to obtain discovery from the district attorney's office.
I object. I don't understand how this court can move forward. I have been very succinct with my motion for discovery.
So
If I understand what you're saying, pardon me, may I continue? Yes?
the way that discovery works is that you are required to go pick it up from the DA's office, okay? So it is not a situation where the court is determining whether the case can proceed. This is not a felony matter where the court is having a preliminary hearing or anything like that. So you have not filed any motions other than the fact that you did not receive discovery. So you know the procedure to get the discovery. You need to go to the DA's office to obtain that.
I'm referring to my motion for discovery, my requests, demands, really. And if I may go back to something you mentioned earlier, Your Honor, respectfully again, if I could have finished what I wanted to read into the record, I come here in peace. But you mentioned that this is not civil, this is criminal. Is that correct?
That is correct.
So there's a crime committed here.
So I'm not going to have these discussions with you, okay? If you want to file a specific motion to have me rule on it, I'm happy to do so. This is not a situation, like I've said several times, where the court is making a determination about a preliminary hearing or anything like that. So you have not filed any motions other than not receiving discovery. I am not going to say that there's no jurisdiction to move forward or anything like that. That is not the situation here, okay? So at this point, you need to go get the discovery from the district attorney's office. I told you that when we set this for trial. If you decide not to do that and don't have that information, that's up to you, okay? So at this point, I'm not going to grant any of your motions because there hasn't been anything that has anything that would have anything to do with a motions hearing at this point. The court is going to deny those requests. We are set for trial readiness on July at 11 o'clock, and then we're set for jury trial on July at 8 o'clock. Trial readiness is the last date that the court will accept any plea agreements. Because you have not filed any endorsement of witnesses or defenses, then you will not be permitted to call any witnesses at trial other than possibly